Hi, it's RCIC Omer from MAK Canadian Immigration Services. And today I'll try to clear a big confusion that revolves around the term known as cohabitation under spousal sponsorship. Whether inland or outland, for both the streams, the term is very much relevant. As a matter of fact, we've had clients who did contact us that there have been procedural fairness letters issued because the immigration officer or the visa officer thinks both the spouses did not do any cohabitation in Canada, as a result of which the officer thinks you guys have entered into this marriage just to obtain Canadian status, which is permanent resident of Canada. So let's dig into this term called cohabitation. Is it mandatory for you to do cohabitation with your spouse, or is it important? Is it required? And if it's not required, does that mean it's not important? Who does it really apply to? Because if you put a question online on a Facebook group, one person will say you do not have to do cohabitation, and the second person will say you must do cohabitation or your application will be refused. So today I'm not going to talk about opinions. We'll focus on the actual rule as per Canada's immigration law and how to avoid choosing the wrong pathway. So let's get right into this now. So the term cohabitation can actually serve dual purposes. Number one, cohabitation can be a legal eligibility rule for a specific class, and that's inland spousal sponsorship. Remember, it's mandatory to do cohabitation if you have applied for inland spousal sponsorship. Number two, cohabitation can be evidence to prove the relationship is real, it's genuine. Now imagine two doors to the same building. Door one is inland spousal sponsorship and door two is outland spousal sponsorship. Both will allow you to establish yourself in Canada as a permanent resident. But the problem is if you walk the wrong door, and it doesn't matter how confident you are, the doorman is not going to let you in. Now to further understand the term cohabitation and who does it really apply to, let's briefly talk about both the classes inland and outland. Under R124 Section A, to be a member of the in Canada class, the applicant must be the spouse or common law partner of the sponsor, and the applicant must cohabit with the sponsor in Canada. So it's mandatory for inland spousal sponsorship applicants. It's not just evidence, it's a mandatory component. Outland spousal sponsorship, and where does the term cohabitation fit in that application? Now, outland sponsorship is generally assessed under the family class framework. So for outland spousal sponsorship applicants, cohabitation, it's not mandatory and it is not required, but it does not mean it is not important. So if you married your spouse and you did some sort of cohabitation back home right after marriage, and pregnancy could be evidence of your cohabitation, and you've sponsored your spouse under the Outland Family Spousal Sponsorship stream, it's really important to throw in that evidence of cohabitation, although it's not mandatory, but it will count towards the genuineness of your relationship. Cohabitation can still be strong evidence of genuine relationship, even if it's not a legal condition for that stream. Now, this is where people blow up their own file or application. Spouse and common law are not the same thing. So if you're applying as common law and choosing outland sponsorship, in that case, cohabitation is not mere evidence. It is part of the definition. You generally need to show you live together in a conjugal relationship for at least 1 year to even be considered as common law partner. You cannot avoid cohabitation by choosing outland if you are applying common law. Keep in mind, cohabitation becomes very important, crucial, and mandatory for common law partners. Now, the rule that applies to everyone. Cohabitation can apply to everyone, whether it's inland, it's outland, it's common law partner. Inland or outland, the officer's real focus is usually the same. Is the relationship genuine? Per R4 is the bad faith rule. A relationship can be refused if it was entered into primarily for immigration purposes, or if it's not genuine. That means even if outland does not require living together in Canada, you still need to prove that your relationship is real with strong, consistent evidence. And there's nothing better than providing evidence to support your cohabitation. And pregnancy can be the prime evidence to support your cohabitation. Ultimately, it will prove that you have a genuine relationship. So to conclude this matter, here's a clean summary. Inland is the stream where a cohabitation in Canada is part of the rule. Under R124A, Outland spousal sponsorship does not have a must cohabit in Canada requirement, but genuineness under R4 applies to everyone. And if you are a common law, cohabitation is going to be central because it's part of the definition. Now, if you're about to submit your spousal sponsorship application inland or outland or as a common law partner, and you're not sure about certain points, and you're looking to choose the safest pathway with the strongest evidence plan, book a consultation with MAC Canadian Immigration Services at the link below. As I mentioned before, I'm a licensed Canadian immigration consultant based in Toronto, Canada. We'll have a detailed chat about your professional profile in which we'll do a complete assessment to see where you stand. And of course, we'll let you know how to move forward. Anyways, that was an important new video and an update. We'll be coming back with more updates. Thank you.